girls' video, they had parts where they just paused and things. So
I guess we can just add it.
Okay.
Am I up first?
Yeah.
Your Honor, may it please the court. My partner and I are representing the petitioners in this case. The question presented is whether the Eighth Amendment's excessive fines clause should be incorporated into the due process clause of the 14th Amendment or the privileges or immunities clause of the 14th Amendment.
Facts of the case. In 2013, Indiana resident Tyson Timms purchased a new Land Rover LR2 for $42,000. He then used the vehicle to transport heroin for several months. Eventually, the police set up a series of controlled purchases in which an undercover agent bought varying amounts of heroin from Timms. Following the controlled purchases, Timms was driving his vehicle when the police stopped and subsequently arrested him. He pleaded down to one count of selling illegal substances and one count of conspiracy to commit theft. These crimes have a maximum fine of $10,000 associated with them. Following the plea deal, Timms paid $1,200 in various fees associated with the proceedings. On top of these fees, the state wanted to seize the Land Rover, which Timms contended violated the excessive fines clause of the Eighth Amendment.
The Supreme Court should not incorporate the excessive fines clause under the due process clause because due process incorporation is inconsistent with the original meaning of the 14th Amendment. The proper avenue for protecting rights against state infringement is instead the privileges or immunities clause, which prevents the states from imposing excessive fines. The securing of fundamental rights cannot be achieved merely through due process, a clause that is in essence aimed at guaranteeing just and fair laws. Privileges or immunities, in contrast, expands the range of protected substantive rights. The Supreme Court should overrule the erroneous Slaughterhouse decision and restore the privileges or immunities clause to its proper place in our Constitution by implementing the test from Washington versus Glucksberg to determine what rights are protected.
We begin, as all constitutional scholars should, with the historical context and drafting of the 14th Amendment. Following the Civil War, the southern states were ignoring and infringing upon the basic liberties of freed slaves. So-called black codes imposed nefarious restrictions on the everyday life of freed slaves. They were not allowed to partake in the same civil liberties as the rest of the population, and the federal government could do nothing to stop the southern states. The expansive reading of the commerce and necessary and proper clauses that we have now did not yet exist, and because of Barron versus Baltimore, the Bill of Rights did not apply to the states. As part of the solution, the framers of the 14th Amendment adopted the Privileges or Immunities Clause.
The term privileges or immunities, while today archaic, was used more readily in the 19th century as a stand-in for the term rights. The 1828 edition of Webster's Dictionary defines right as just claim, immunity, privilege. As Justice Thomas notes in his McDonald versus City of Chicago concurrence, the 1865 edition adopts an almost identical definition. The legislative history of the Privileges or Immunities Clause is very conclusive. Floor statements from Representative John Bingham of Ohio, among others, tell us exactly what the framers understood the clause to mean. The framers intended and understood the 14th Amendment to radically alter the relationship between states and the federal government. The 14th Amendment's clause tracks the language of Article 4, Section 2 of the Constitution's Privileges and Immunities Clause. Ultimately, the Privileges or Immunities Clause of the 14th Amendment draws significant elements from the Privileges and Immunities Clause. Privileges and immunities, as defined by Justice Washington during the Porfield versus Coriell case, are in their nature fundamental, which belong of right citizens of all free governments, and which have, at all times, been enjoyed by the citizens of the several states which compose the Union. These defining characteristics were explicitly referenced and invoked by Senator Jacob Howard in speeches during the passage of the 14th Amendment. Thus, the original framing of the 14th Amendment encompasses protection for, amongst other things, certain historically recognized rights.
If the framers had wished to simply enact an amendment that overruled Barron versus Baltimore, they could have done so easily. Instead, they chose the Privileges or Immunities Clause, which cannot be understood as either a restatement of Article 4, Section 2, or as an entirely different clause. However, rather than its scope being more narrow than previous clauses, in the words of Professor Akhil Amar, it adds, quote, several improvements to the old, implying a focus solely on civil rights. The clause modifies previous provisions by eliminating confusing references and exceptions, and is tailored to protect the rights of freedmen in a post-Civil War era. It is important to understand this context and observe that the clause was framed to protect citizens from abuse of state power. The effects of the clause, therefore, must be understood as being responsive to the contemporaneous political climate.
We propose that the Court utilize the Glucksberg test to decide what constitutes a privilege or immunity of citizens of the United States. The Glucksberg test provides that when a right is deeply rooted in our nation's history and traditions and clearly defined, it is protected by due process. We propose the court shift this over to privileges or immunities. Glucksberg, unlike many other substantive due process tests, looks explicitly towards history, does not ask whether a right is implied by the general aura of the Constitution, or whether the denial of a right would violate a nebulous concept such as liberty. Instead, it requires a thorough historical analysis to determine whether or not a particular right is protected by the text of the 14th Amendment. This careful historical analysis, reliant on history, is exactly what is required to ascertain the meaning of a clause such as privileges or immunities. This historical approach is in stark contrast with the less defined and more open-ended substantive due process tests that the court has used in the past, such as the ones that the court uses to determine dignity interest. As is evident, those tests are far more subjective than the historically grounded Glucksberg. Perhaps the most compelling argument for adopting Glucksberg is that it is the best way we have of determining what rights are constitutionally protected privileges or immunities.
Using the Glucksberg framework, in which clearly defined constitutional protections are encompassed by privileges or immunities, the excessive fines clause becomes inherently applicable. Stated originally in the 8th Amendment as excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted, the language itself has been traced by William Blackstone to various historical traditions, including the Virginia Declaration of Rights, which borrowed from the 1689 English Bill of Rights. Additionally, throughout the establishment of various colonies, including Pennsylvania, provisions that sought to eliminate excessive fines have been included in various governing documents. One example of this enumeration is the Northwest Ordinances, which specifically prohibits excessive fines. When it was ratified, the doctrine that was so ever present in our nation's history became widely considered to be fundamental by even those who opposed the Bill of Rights, such as Edmund Randolph, who thought of the right as so fundamental that it was foolish to enumerate it. The extent to which the concept of protection against excessive fines can be traced in our nation's history shows that it is deeply rooted in our traditions and must therefore qualify as a privilege or immunity.
Stare decisis. While the legal merits of stare decisis are many and varied, they are not, as the Supreme Court has itself noted, an inexorable command. And although the rule of law and consistency are values that are central to our judiciary, blind fealty to prior cases is surely incorrect. Lady Justice may indeed be blind, but the judiciary cannot afford to be. The court has many times re-examined prior decisions, most notably in cases such as Lawrence versus Texas, Brown versus Board of Education, West Coast Hotel versus Parrish. As we speak, it is set to review the decisions of our own Seminole Rock.
The most salient features of any potent stare decisis argument are the reliance interests. In this case, however, they are conspicuously absent. Lawrence Tribe remarks that it cannot be said that the slaughterhouse cases have resulted in any reliance interest such that overturning it would result in hardship or inequity. This has become blatantly obvious when the case is compared with similar legal cases or legal questions which also involve stare decisis analysis. Unlike Casey versus Planned Parenthood, slaughterhouse is not deeply ingrained in our culture. Serious uproar would not be caused if it were overturned. Unlike Wickard versus Filburn or Humphreys executor, it does not act as the basis for congressional action or government policymaking. Those are the sorts of reliance interests that the court accepts. Slaughterhouse simply cannot compare to them. To put slaughterhouse in the same category as abortion cases, civil rights cases, and landmark cases concerning the most fundamental structural provisions of the Constitution is not only incorrect, but devalues the important legal principle of stare decisis.
In conclusion, because of the extremely errant nature of the decision and lack of stare decisis concerns, the court should overrule slaughterhouse. It should shun the incorrect and historically deficient due process incorporation model and restore the privileges or immunities clause to its proper place by using the Glucksberg test to determine what constitutes a privilege or immunity of citizens of the United States. Under this test, the court should hold that because the right against excessive fines is deeply rooted in history, it is a constitutionally protected privilege or immunity. Pursuant to that holding, it should reverse and remand for further proceedings.
Should the 8th Amendment's excessive fines clause apply to the states?
So as we already stated that it should apply to the states, but the method of incorporation should be through privileges or immunities and not the due process clause, because the due process incorporation is historically inconsistent and stretches the meaning of it too far, whereas privileges or immunities actually affirms the substantive rights.
Please explain what the privilege or immunities clause of the 14th Amendment prohibits, Why is it the most important vehicle for applying federal constitutional rights to the states?
Well, the Privileges or Immunities Clause, as we explained, protects a panoply of deeply rooted historical rights. Examples of this would be a right to free speech, or a right to keep and bear arms, or as we explained here, a right against excessive fines. The reason that Privileges or Immunities is most important is because that is the clause of the 14th Amendment that protects rights such as free speech. That protects rights against self-incrimination. The Due Process Clause really is a prohibition on irrational and arbitrary laws. It protects liberty, but in a very different way than Privileges or Immunities. What due process does fundamentally is very different than what Privileges or Immunities does, and the difference should be recognized, and Privileges or Immunities' paramount role should be reasserted.
Why shouldn't we, the justices, apply the excessive fines clause to the states via the due process clause of the 14th Amendment?
Well, ultimately, as my partner Curtis just stated, is that the Privilege or Immunities Clause is more consistent with what it was meant to be, as it was outlined in the 14th Amendment, and it is something that actually affirms that right in and of itself, whereas the Due Process Clause, if we were to use that means to incorporate the excessive fines, then we would be stretching its usage and stretching it to a bounds that it really would not be effective.
Does it matter which part of the 14th Amendment we use to incorporate the excessive fine clause? Please cite past court cases and historical materials to support your position.
Well, I think it absolutely matters which clause we use to protect substantive rights. The Constitution, its original meaning, commands are that we adhere to the text of the Constitution, and that we not make up various approaches that are simply inconsistent with that text. Due process really has never been understood until very, very recently to incorporate the Bill of Rights. What it has been understood to do is protect against irrational and arbitrary laws. And in cases such as Lochner versus New York, the court takes this approach too far and begins inserting its own judgment in place of the elected people's. Caroline Products, the court steps back from that approach. And in Williamson versus Leoptical, the court perhaps takes it too far in the other direction, deferring perhaps too much to the legislature. But throughout these cases, due process clause really isn't understood to incorporate the Bill of Rights. It's a modern concept. It's not something that the framers would have understood to be the original meaning of the Constitution. As Justice Thomas notes in his concurrence in McDonald versus City of Chicago and his dissent in Saines versus Roe, that's just not the role of the Due Process Clause. The role of the Privileges or Immunities Clause is to protect these substantive rights that we're incorporating through due process.
What is the scope of the 8th Amendment's prohibition on excessive fines if we extend it to the states? How do we determine the scope of this right? What is the scope of the 8th Amendment's prohibition on excessive fines if we extend it to the states? How do we determine the scope of this right?
Well, a right against excessive fines is defined in large part by the common law history, but notably also has to include in rem forfeitures, such as the forfeiture that is at issue in this case. In oral argument, the lawyer for Indiana makes several arguments in an attempt to distinguish in rem forfeitures from an excessive monetary fine. These arguments, however, are ultimately unavailing. He's peppered by questions that reveal the poor nature of the distinction, in that once you acknowledge that in rem forfeitures are not constitutionally prohibited if they are not proportional to the monetary fine that's permitted for a certain offense, then you remove a lot of protection against individual liberty. As Justice Breyer it pithily notes, what if the airplane is speeding? What if the billionaire in his Bugatti is driving 5 miles an hour over the speed limit, and because the vehicle or the airplane is material to the crime being committed, can the state simply forfeit it? There's really a lack of limiting principle once you say that in rem forfeitures are completely separate from excessive fines. I think the two must necessarily be combined.
Assume that we incorporate the excessive fines clause in this case. Does the forfeiture of Mr. Tim's vehicle amount to an excessive fine? Why or why not? Please explain your legal analysis.
Well, as I just said, sorry. Go ahead.
Yeah, it would apply as an excessive fine because we have to distinguish between actual monetary confiscation and, as we said, in rem forfeitures, in which, as we were talking about the example of speeding of an airplane. These are like material examples of things, and they cannot necessarily be translated to the same value as the monetary confiscations. And so, yeah, we would say that that would definitely be an excessive fine.
Are civil forfeitures ever appropriate as a punishment under the excessive fines clause?
Well, perhaps they are appropriate as a punishment. That's not a judgment for us to make or for judges to make. That's a judgment for elected officials to make. They're the persons who the Constitution and we the people have designated to make a judgment about whether an in rem forfeiture is appropriate. But the judgment that the judiciary is obligated to make is whether or not the forfeiture is excessive. If it is severely disproportionate to the crime that is committed, then the court will be obligated to strike down that action as unconstitutional, as an excessive fine.
All right, thank you. That's all we have for you.
Video.
Okay, is there any